for Katiba Institute, who not too long ago approached the High Court saying that the bill or the act, as it's now an act, is unconstitutional. I'm referring to the Election Laws Amendment Act, my lords. That contest is a live contest in the High Court. Yes, Mr. Waikwa, Mr. Omtata, quite a number of my good friends have gone to the High Court to challenge and say that the act is unconstitutional. And the High Court is again being requested to make a determination on whether the act is constitutional. The High Court is exercising the power under Article 165, sub-Article 3, paragraph D. My lords, that is a live contest in the proper courts. Once again, I would request you, my lords, to decline any invitation. Decline any invitation made to you to, at this stage, declare whether the act is constitutional or is not constitutional. Because that is a live contest in the proper court. But because the act is an act of parliament, regularly legislated, it ought to be applied unless the High Court or any other court exercising an appellate process declares that that law is invalid. Before any such declaration, my lords, that becomes the regulating law within our republic. My lords, I'm looking for some notes I had, but I can still argue from memory, I think. The last point I would wish to discuss is a point that was raised once again by my good friend Mr. Waikwa yesterday in his submissions. He submitted that no opportunity was given to voters in 27 constituencies to exercise their constitutional right. Number 1 is erroneous because that includes the constituency in Turkana and Fafi. You remove those two constituencies, you are left with a number of 25 constituencies. In his argument, my lords, he very passionately urged that because there wasn't an election in those 25 constituencies, that would be enough ground to invalidate the fresh presidential election.